Hello, ladies and gentlemen. Emeka Ogwonye speaking today, the 8th of April 2022. I am speaking from Abuja, actually. I came to Abuja because I knew that today was going to be a decisive day in the case of Nnamdi Kanu. Today was the date that the judge had set 2 months ago to deliver a ruling on an important set of applications in the Nnamdi's case. During the last time when this case came up, I was forced to make a prediction on what today was going to look like. And I remembered vividly that I predicted that there was no way the Federal High Court, Abuja, was going to decline jurisdiction completely in the Nnamdi's case. However, I considered that the defense team led by Mike Ezekome made a very passionate and powerful presentation. And as a result, I predicted that the court was going to strike out a number of the charges, the amended charges that the DSS, on behalf of Nigerian government, had filed against Nnamdi Kanu. As I indicated then, I said the issues involved in this case are so profound that there was no way the Nigerian court would totally decline jurisdiction and throw the case out. So much is at stake. So much discussion going on, so much consultation going on, so much politicking going on this case, and so much continuing violence associated with the IPOB campaign for Biafra. I knew there was no way the Nigerian judiciary was going to hands off this case. If that had happened, it would spell more doom than resolve the problems. And today, true to my prediction, the court struck out a number of the charges and retained 8 of them. The implication of retaining even one of those charges is that the court remains involved. It means that the court accepted it has jurisdiction to adjudicate this case irrespective of the implications of rendition, which, as you know, was the gravamen of the argument of Nnamdi Kanu's defense team. So it came to pass, just as predicted, that the Anyanko court retains jurisdiction over this case. It also came to pass that the application regarding where to detain Nnamdi failed. Nnamdi's detention remains with the DSS, but not just that. There was a recent development. As recently as yesterday, the Federal High Court Chief Judge, Justice John Soho, issued a new practice directory. And what does practice directory mean? Practice directory is not law because it's not made by the legislature. However, it contains a series of rules made by the judiciary itself on how it conducts its business. So the practice directory that was issued yesterday had profound implications on the case of Nnamdi Kanu. It was couched as a practice directory to govern the trial of terrorism cases. So it wasn't something meant for Nnamdi's case alone, and it is wrong to perceive it only from the perspective of Nnamdi's case. However, it has a profound implication on Nnamdi's case. The new directory suggests the following. First and foremost, it will bar the judiciary from access to trial. It will bar the media. I beg your pardon. It will bar the media access to terrorism trials. It will also restrict the reportage on such cases. It will also offer screening for some witnesses. It was, by implication, a secret trial now ordered through practice directory. And if implemented right away as it is intended to be implemented, it will affect not only incoming cases, but pending cases, including the case of Nnamdi Kanu. So the further proceedings in the Nnamdi Kanu's case will be caught up under the new practice directory. It has profound implications, not just for Nnamdi, but let's look at the broader question of how this practice directory affects trials of certain cases in Nigeria. First, we must admit that the Nigerian courts are overwhelmed or likely to be overwhelmed with terrorism cases. The cases of Boko Haram members are coming up. The cases of members of the bandit court are coming up. The cases of all those courts associated with IPOB, ESN activities in the eastern part of Nigeria are coming up for trial. And of course, the ISIS for West African team are coming up. Nigerian courts are clearly inundated, and this is a judicial system that had been inadequate to address the conventional crimes in Nigeria. Now being overwhelmed by these new batch of terrorism trials and cases, the court had to do something. The court had to brace itself and prepare for these type of cases. But the preparation the court should embark upon will not be limited on these practice directory alone. The court's supposed to find a way to speed up trial generally. Cases are not supposed to linger for months, for years, without progress, as we have seen in the Nnamdi's case. Nnamdi was brought into Nigeria in June of 2021. Almost 8 months now. Indeed, I would say 10 months now. Since then and this moment, there has been no progress. And much of the delay in that case has been caused by the government. For instance, the DSS, even though they had Nnamdi in June, even though they had him in custody, even though they took years and months to prepare for the case, leading all the way to renditioning him to Nigeria, yet the DSS was not able to come up with the charges in the Nnamdi's case until months after. It took them about 4 or 5 months before they came up with what they call the amended charges, some of which have been slashed today. So the delays in these trials are actually the problem, the number one problem. And not just the issue of exposure, the issue of security that the court faced. So it is quite alarming that the court has not come up with any process to facilitate speed, to expedite these trials. Instead, the court is concerned only about security. Now, is the court justified in doing something? Yes, the court is justified. There is no doubt from anybody who has observed the Nnamdi's case, no doubt that the court is overwhelmed. The court is inundated. There had been no other case in recent times like the case of Nnamdi Kanu. Each time the case comes up, thousands of people, supporters of Nnamdi Kanu and supporters of Biafra, will inundate the surroundings of the court, creating extraordinary difficulties and impasse. So if Nnamdi's trial is proceeding in a court with so many other courtrooms available, the entire court is paralyzed. The security activities, holding people at the gates, preventing entrance and access and exit from the court, all these things will automatically affect all other cases pending in court. So each time a Nnamdi's case comes up, nothing else happens in that court. No other case goes on in that court. We saw this in Abuja. We saw this in Umuahia. When Nnamdi's fundamental right enforcement proceedings were going on in Umuahia, the court, the entire environment, the entire surrounding and neighboring streets of the court premises were inundated, forcing the court to move the venue to somewhere away from Umuahia main court building. So apparently, the Federal High Court building in Maitama, Abuja was overwhelmed and something was going to be done. So part of the things achieved today in the practice directory, the new practice directory that was rolled out yesterday, is that the venue for the trial of such cases, including the Nnamdi's cases, will now hold elsewhere. And they have chosen in the interim the one of the bureaus, Asset Declaration Bureau or something, for these trials to go on. What do you expect to change now? Nothing much. Supporters of Nnamdi will still besiege that court, that venue, that environment. That's not going to change. The supporters will still come. What is going to change is that the Nnamdi's trial will no longer paralyze all other cases pending at the Federal High Court in Maitama building going forward. So, that is as it is. But also, before we go, we have to ask the larger question. which is, how does the new practice directory fare when compared with the urgent need for due process and fairness in the Nigerian trial cases, in Nigerian court cases? It is fair to say that the new practice directory undermines fairness. It undermines due process. It indeed tilts the balance further against the suspects, the defendants. It enables the state to further abuse the rights of defendants or further undermine due process. I will explain this. The practice directory is anchored on the question of whether a case is a terrorism case. It kicks in only when a case is considered terrorism case. So it is important for us to ask, what makes a case a terrorism case? So it boils down to what we call the charging decision. It is at the time you charge a person that those who decide what charges to frame will decide to make a case a terrorism case or something else. So the real decision over this practice directory is not a judicial decision. It is going to be the decision of the DSS, the police, or Nigerian government, the executive arm of government. So it is up to them to decide which case they will classify as terrorism case. This is not simple. It's a serious problem. Because in Nigeria, the standards for charging decision are low. They are susceptible to corruption. They are susceptible to bias. They are susceptible to ineptitude and incompetence. I will prove it to you. The DSS can actually call any case terrorism case. And the reason they do this is because they want to justify unlawful, extraordinary detention of the people involved. In 2015, when Nnamdi Kanu was arrested for the first time, there was actually no terrorism in the facts of the case of Nnamdi. No terrorism at all. But the DSS deliberately classified that case terrorism in October 2015 because they wanted to detain Nnamdi. It was early in 2017 that the court struck off the terrorism charges in the Nnamdi's case. In other words, nearly 2 years after he was classified as a terrorism case, the court determined that there was no terrorism in it. But by then, Nnamdi had been subjected to harsh terrorism trials for 2 years. Also in the case of Sowore, Omoyere Sowore, who began to call for a protest. Clearly, Showore's case was more of a nuisance or breach of peace or incitement. That was it. There was no terrorism in Showore's case. But because the DSS wanted to justify detention of Sowore, they classified Showore's case initially as terrorism case. Because they classified it as terrorism case, they felt justified to detain Sowore for 90 days. If you noticed in that case, when Falana, Showore's lawyer, filed an application for the release of Sowore, he challenged the notion that there was terrorism in the case. And the DSS never responded. DSS was never able to show Justice Taiwo that there was terrorism element in the Showore's charges. Yet, they were able to use that terrorism charge as an excuse to detain him for 90 days, which would not have been possible if he was not charged with terrorism. So, we're supposed to be concerned about the arbitrariness, the abuses of the charging decision made by the DSS. So the practice directory we had released yesterday is lacking grossly because it failed to protect people against arbitrary charging of terrorism. It failed to protect those who will be arbitrarily, corruptly charged with false terrorism cases. So, the practice directory, I will admit that I have not fully read every part of it, but I'm going to say that unless the practice directory has a provision to enable people to preliminarily challenge the terrorism charge, to determine indeed that there is a basis to justify the charge, unless we have it in the practice directory. The practice directory is a giveaway to the DSS. It is a blank check given to the executive to abuse the rights of the people. So I hope the focus shall be, if your client is charged arbitrarily, wrongly, with terrorism charges, there must be a procedure for you to bring an application within a week, asking the judiciary, the court, to determine whether or not the facts justified terrorism charges. Only then will it be justified to take a person, lock him up, because you have falsely accused him of terrorism offenses. So this is the dilemma. These are what we should be dealing with. These are what we are worried about. But there is no doubt in my mind that the practice directory issued yesterday has complicated the case of Nnamdi Kanu. It has also complicated not just for Nnamdi Kanu, but also for the government of Nigeria, because it interjects further political elements into the case. People who cry against the trial on the basis that it is abusive will not stop crying. Indeed, their voices will rise in light of the practice directory. Thank you so much for listening. I will continue to present updates on that case. I will also present updates on the implications of the practice directory on all other pending cases. For instance, if you go to Kuje, so many cases in Kuje, so many people in the inmates in Kuje are facing terrorism charges. So what then is the procedure? What's going to happen? Because apparently, with the practice directory that says it could take evidence remotely, it means that the DSS don't need to bring Nnamdi Kanu to any court. They can put him in a room in their office and wire it up with internet and cameras and have Nnamdi tried in such a manner. So we expect profound agitation. We expect profound questions to be asked on the new practice directory. Thank you, and have a great weekend.